You've been arrested for domestic violence in Florida. What's going to happen at your first appearance court date? In this video, I'm going to talk all things first appearance, aka Magistrate Court for domestic violence cases. I'm Adam Rossen with the Rossen Law Firm, and in today's video, we're going to be talking about domestic violence and what happens at first appearance court. So before we begin about first appearance court, let's just talk briefly about domestic violence. So domestic violence is usually more or less any type of assault or battery that has a domestic component to it. So people living together, people who have children in common, people who are part of a family unit is roughly what domestic violence means. Now, in Florida, we have many types of domestic violence. It could be misdemeanor domestic violence battery. We could talk misdemeanor domestic violence assault, or we can go into some of the more complicated felonies. So DV by strangulation, aggravated battery on a pregnant female, domestic violence, aggravated battery with a deadly weapon causing great bodily harm, or aggravated assault. There are even some other ancillary charges that are technically not battery related. It could be unlawful, basically interference with a 911 call, tampering with evidence. Those things can be associated with domestic violence charges. But for the purpose of today, you're not going to get into domestic violence court or be there for first appearance unless there's usually a DV battery or assault or some kind of violent charge attached with it. So now that I've gone over some of the domestic violence type of charges, well, let's talk about what happens when you're arrested, booked, taken to jail. So in Florida, domestic violence is going to be a hold for magistrate. And what does that mean? It means you are not going to get an automatic bond. So in a lot of counties, you get a DUI or you get maybe a trespass or some other types of misdemeanors or felonies, could even be a possession of cocaine. They'll give you what's called a standard or a scheduled bond. Might be $1,000, $2,500, whatever it is. And by the time you get to jail and they process you, if you have a standard or a scheduled bond and you have the money on you, you could just bond yourself out right away. Or your family can bond you out, or they can hire a bail bondsman and just get you out right away within a few hours, meaning you won't have to wait until you see the judge. But on all domestic violence charges, you must wait until you see the judge. And so usually that's going to be the next day. Depending on timing, especially on weekends, you could be in jail for 2 or 3 days, just depending on the timing. So that's, obviously an issue as well. But what's going to happen when you get to court and you see that judge? So when you see the judge, there's going to be a prosecutor there reading off the probable cause affidavit. The police usually won't be there, and the public defender might be there. But you can also hire a private attorney, a criminal defense attorney that's paid to come and advocate and fight for you at first appearance court. So when we go there, first of all, a lot of times we're going to try to negotiate things in advance. The less that we have to fight over, the better. But the judge is going to want to be very concerned about certain factors. So one of the major big decisions is, do they put you on pretrial release or some form of supervised release? Or do they give you a straight monetary or money bond? Or do they do a combination of both? Now, personally, I don't like when my clients are on supervised or pretrial release just because there's more opportunities for them to make mistakes and go back to jail. It's kind of like having Big Brother watch you or you being on probation while the case is going on. And that's why we generally don't want our clients to be on that unless we have to. But what are some of the stipulations that they're going to ask? Well, if alcohol was involved in this domestic violence case, then the prosecutors could ask the judge for random urine testing at your own expense, and to be ordered not to have any drugs or alcohol in their system. There's going to be a no contact order, and that will extend to the alleged victim through direct and indirect parties and contact. Usually it'll extend to where they live. So if you share a house and the alleged victim is going to be in the house, then you're getting kicked out. And you're going to have to couch surf, live on a friend's sofa or bedroom, or pay for a hotel. And that could cost tons of money. Also, what's going to happen with contact for the children? That's a big deal as well. And all of these things can be discussed and determined. Just because the default is no contact doesn't mean that at first appearance, if it's done properly, that a good lawyer or a great law firm can't get you contact at first appearance. And there's lots of different types of contact that can be got. It could be just full contact, no restrictions. It could be no harmful contact. It could be phone contact only, no in-person contact. Or it could be phone contact to discuss the children only, or it could be contact through third parties to discuss the children and coordinate pickups and drop-offs and things like that. So all of those things can be decided and negotiated at first appearance court. In addition to the amount of bond, well, there's a big difference between a $10,000 bond and a $2,500 bond. Or what levels of supervision, of call-in, of in-person check-ins on pretrial release or supervised release there is. So there's a multitude of things that are going on in domestic violence court for first appearance that are kind of unique to domestic violence cases. You know, in any type of case, they're going to talk about monitoring you through pretrial release versus money, but they're not going to have the no contact orders, the drugs and alcohol potential issues, contact for children, all those other things that domestic violence court is going to address and handle. So these are very important considerations. If you find yourself in a situation where, oh my God, a loved one just got arrested, what do I do, right? What you need to do is call expert attorneys immediately because they can guide you through the system. One of the other things that's really important is, well, knowing which bail bondsmen are helpful and which aren't. Bail bondsmen are a lot like criminal defense lawyers. There's a very big difference in who you get, and you got to do some research on that. So I can tell you, for example, for us, we only use the absolute best bail bondsmen that are professional, courteous, kind, easy to work with, and they're fast, meaning they're going to post that bond very quickly to get your loved one out of jail as soon as possible. And to me, that matters. That makes a big difference. That's the way it should be done. So there's so many considerations if this is going on right now. Give us a call if you're ever in this situation, 754-206-6200.